Welcome once again. In today's lecture, we will discuss about some more legal concepts. In the beginning, we will learn the term offense. The term offense is an act. Term offense is explained as an act, or it may be omission. An act or omission prohibited under criminal law. And if any person contravenes the provision of a criminal law, there is a provision of a punishment also. So offense may be explained as an act or an omission which is prohibited by criminal law and which is punishable under the Indian Penal Code. Offense means the violation, any contravention, disregard, disobedience or non-observance of a legal right of any persons. Under the Indian Penal Code, there is a range or there are various offences stated in the Indian Penal Code. These offences may be classified as the offences against the person, means to assault someone or to make murder of someone. It is called as the offences against the persons. Theft or to trespass on the land belonging to another person are the offences against the property. And there are certain offences relating to the intellectual property, means the offences against the copyright, trademark, goodwill, etc. etc. So the offense means any act or a omission which is made punishable under criminal law and which is prevented by the criminal law. Then we will discuss another important concept, complaint. In our day-to-day life, we heard the word complaint. So complaint is allegation. Complaint means allegation. Whenever there is any allegation raised, but these allegations should be regarding that the offense is committed. If the person make an allegation that the offense is committed by the persons, whether known or unknown, this complaint or this allegation made to the magistrate with the intention or with the purpose to take an action under the criminal law. The person who making an allegation is called as a complainant. If any particular criminal matter considered as a complaint, the following ingredients or following essentials should be fulfilled. First of all, it should be an allegations regarding the commission of an offense. The person who committed an offense may or may not be known or unknown. The allegation may be orally or in writing addressed to the magistrate, and the object or intention behind this allegation is to take an action under the criminal law or other any relevant law for the time being enforced. So in short, we can say that complaint is a oral or written allegation made to magistrate that certain person, known or unknown, has committed an offence and particular action under the criminal law or under any law time being enforced should be taken. Okay. Then third important legal concept is a charge. Charge means an accusation of an offence. If any particular complaint is filed against any accused, there should be specific accusation against that accused. And these offences or these accusation of offences travel under the criminal law. If we will take one example, if one person filed any complaints against another person regarding the theft. So in this case, the robbery is a charge which is framed against the accused person. So charge is an accusation and charge sheet is an record which is properly maintained regarding the accusation against the accused person. So charge are the accusation and this accusation regarding an offence. So charge sheet is one of the important document. So through these charges or through this charge sheet, accused come to know the specific accusation which are used against him. So the object of a charge is to give the precise notice or a precise or clear idea to the accused person regarding the accusation levied against him. So charge is an accusation. In fourth stage, discharge. A particular complaint is filed against an accused person and if accused brought before the magistrate or before the court. After examining the evidences brought by the prosecution and accused and after hearing both of the parties, if the court considered that there is a no prima facie case or there is a no sufficient ground to further proceeding against the accused person. I will repeat once again. If particular accusation or a particular charges made against an accused person and that accused person brought before the court and after examining the evidences submitted by the both parties, means prosecution or complainant and the accused person, and after hearing both of the parties, if the court considered that there is a no sufficient ground to proceed against the accused person, at that time the court discharged that particular accused person. Okay, it means that court discharged the accused, means set at liberty in the proceeding. Okay, in the beginning, after hearing the evidences and after hearing the both sides, if the court consider that there is a no evidence, then magistrate or a court discharge that accused person. It is called as a discharge. Okay, charge means accusation and discharge means to make a free from all these charges. Okay, then in the next step we will discuss about the bail. Bail means a security or a guarantee given to the court. Bail is a security that he will remain present on the day of a trial. If a person accused of any offences and if he is imprisoned or if he is in custody and if he is brought before the court, then he have to give some surety or a security or a guarantee to the court that he will remain present for further proceeding against him. So, bail is a procedure through which the accused person give guarantee to the court that he will remain present and court set release him. But this release is a temporary relief. Okay? If the court find that the person is arrested or imprisoned or in a custody and the offences charged against him are bailable offences, then court set at liberty to that accused person. So, bail is a matter of right in case of a bailable offences. If we discuss or if we read the IPC, then we come to know which are the bailable offences and which are the non-bailable offences. Under the Criminal Procedure Code also there is a provision regarding the bailable offences and non-bailable offences. In a bailable offences, bail is a matter of a right of an accused person. In this matter, court or a magistrate did not have discretion. Means if the accused produce or accused give a surety or a security for his attendance in a court in the future trial, then at that time court must release him on a bail. But in case of a non-bailable offences, it is a matter of right. It is a discretionary power vested in a court to give bail or not. So bail is a sum of money which is put forward by the accused person, sometimes relatives of the accused person or sometimes friends of the accused person. If accused person fails to present for the trial, then at that time his money given in a security or a guarantee are lost. Okay. Then we will discuss about the acquittal and conviction. If in the beginning, we already discussed, if in the beginning court find that no prima facie case. So in the beginning of the proceeding, court find that no prima facie case or no sufficient right to further proceeding, at that time discharge the accused. But in the end of the case, in the end of the criminal case, if the court consider that or if court come to the decision that there is no sufficient ground the charge against the accused is not proved beyond the reasonable doubt. If in the end of the case or if in the decision in the criminal case, at that time if the court consider that the charge against the accused person did not prove beyond the reasonable doubt, at that time court set at liberty to the accused person. There may be evidences against the accused person, but these evidences are not proved beyond the reasonable doubt. So, court set at liberty to that accused, record the reason for acquittal of an accused person and make an order of acquittal. So, this order of acquittal is barred to subsequent prosecution against the accused person. It means that if that accused person acquitted from that particular offense, no person can file the complaint or a criminal case against him on a same charge or regarding same offences. And in the last conviction, it is opposite to the acquittal. If at the end of the criminal proceeding, or it is an end of a criminal case, that if the charges levied against the accused person proved beyond the reasonable doubt, it means that the accused found guilty of that particular offense, then at that time court make an order of a conviction. It means that accused person found guilty of that particular offense which is charged against him, and at that time court make an order of a conviction because the case or charge against him proved beyond the reasonable doubt, and at that time court sentenced him. The range of a sentence is under the Indian Penal Code is a imprisonment, life imprisonment, or a fine, forfeiture of a property, etc. etc. Okay? If the accused are found guilty beyond the reasonable doubt, then at that time court make an order of a conviction, record the reason for order of a conviction, and at that time sentence him, which is stated in a Indian Penal Code. So all these concepts are very important concepts in the criminal law. Thank you very much.